what is commerce? What would be economic and not commerce? Well, the original meaning of commerce, which has never been formally changed by the Supreme Court, concerned the buying and selling and trading and transportation of goods across state lines. It was trade. That's what commerce meant. And the original meaning of commerce did not include, for example, such economic activities as farming or agriculture or manufacturing. Those were considered to be economic activities that were governed by the police powers of the various states. That's the original meaning of commerce. The Supreme Court's never formally changed that meaning. What it did do is it said that the Congress can reach activities that are not strictly speaking commerce, such as manufacturing and agriculture and a variety of other economic activities that are existing within the states, if those activities have a substantial effect upon interstate commerce. And that's the power, other than the spending power, that Congress most often utilizes to regulate activities throughout the country. So after the New Deal, what most law professors taught about the power of Congress was that Congress could pretty much regulate whatever it chose to. And for about 50 or 60 years, that was largely the case. Congress not only thought it could regulate it, not only did law professors think that Congress could pretty much regulate whatever it wanted to, Congress thought it could regulate pretty much whatever it wanted to. And so in 1995, when Congress passed the Gun-Free School Zone Act, and that case went up to the Supreme Court and it was decided, law professors were shocked to discover that the Commerce Clause did have a limit when it held that the Gun-Free School Zone Act, which was an act that prohibited the possession of guns within 1,000 feet of a school throughout the country, exceeded the powers of Congress under its commerce power. And why was that? It was because the Supreme Court said you have to look at the class of activities that Congress is seeking to regulate. And in the Gun-Free School Zone Act, the class of activities was the possession of guns within 1,000 feet of a school. That is not economic activity. It's intrastate activity, but it's not economic activity. And because it's not economic activity, you don't even ask whether it has a substantial effect on commerce, interstate commerce. The Supreme Court said that it's only when the intrastate activity is economic in nature do we then allow Congress to reach it if it has a substantial effect on interstate commerce. This was news to Congress. It was news to law professors, and it was a big surprise. And after Lopez versus United States, which is the name of the case, United States versus Lopez, law professors thought, well, you know, we're not really sure the Supreme Court really means this. And in fact, Congress had gotten so lazy in the 50 years preceding Lopez that it didn't even make findings when it passed the Gun-Free School Zone Act that said that having a gun within 1,000 feet of the school had a substantial effect on interstate commerce. So we predict, said the law professors, that if Congress were just to make findings that said that this intrastate activity had a substantial effect on Congress, then the Supreme Court would defer to that and would uphold any laws, provided Congress jumped through the hoop of having hearings and having findings. So law professors, again, were really, really surprised in the year 2000 when the Violence Against Women Act was litigated and brought to the Supreme Court. And the Violence Against Women Act, part of it, created a federal cause of action for what was called gender-motivated violence. And the Supreme Court struck that down as being beyond the power of Congress to make under the Commerce Clause, notwithstanding the fact that there had been weeks and weeks of hearings and mounds of findings that said that violence against women or gender-motivated violence had a substantial effect on interstate commerce. And what the Supreme Court said in U.S. v. Morrison was that committing a crime against a woman or committing a crime because you're motivated by gender, which is what actually was what the law addressed, was not economic activity. And because it was not economic activity, it didn't matter if it had a substantial effect on commerce. Congress still didn't have the power to reach this wholly intrastate activity. So this was a really big surprise now to law professors. And after this, lower courts started to take this Commerce Clause idea a lot more seriously, and there started to be a lot more challenges, including, for example, a challenge that I was one of the lawyers to bring to the Controlled Substances Act and to the application of the Controlled Substances Act against cannabis or marijuana that was being used in California for medical purposes as authorized by state law. And I brought a lawsuit on behalf of Angel Raich and Diane Monson, which went to the Supreme Court and tested the limits of the Commerce Clause, and we argued that it was beyond the powers of Congress to reach this wholly intrastate non-economic activity that was basically growing marijuana for your own use as authorized by state law for medical purposes. And we went to the Supreme Court, and in 2005, we lost that case. We lost that case 6-3. We got the votes of Chief Justice Rehnquist and Justice Thomas and Justice O'Connor. But we lost the liberal side of the court and Justice Scalia and Kennedy. And the court said that Congress did have the power to reach this wholly intrastate activity. But it's very interesting to see how the majority of the court reasoned, why the majority of the court upheld this application of the Controlled Substances Act. They did so expressly because, based on a 1966 Webster's Dictionary definition of economic, that economic activity included the manufacturing or the production and distribution and possession of commodities. And since marijuana was a commodity, the production and possession of that commodity was economic in nature, and therefore Congress could reach it, unlike the possession of a gun within 1,000 feet of a school, unlike the commission of gender-motivated violence. The growing and the possession of marijuana was economic in nature, and Congress could reach it. Well, after Raich turned away this Commerce Clause challenge, law professors kind of went back to their original position. Congress can do whatever it wants. So they've totally reverted to their pre-Lopez view of what powers Congress has. And I believe this bill was passed more or less with that understanding in mind. But it turns out that if you actually look at what the individual mandate requires, it is doing something that has never been done before in this country, using the Commerce Clause power. Every other exertion of the Commerce Clause power that's ever been done by Congress has been an exertion of power, of its power to regulate or to prohibit. Never in the history of the country has that power been used to mandate that individuals enter into economic activity. It's been used to regulate economic activity, it's been used to prohibit economic activity, but it's never been used to require that people who are not engaged in economic activity do so. That makes this something that has never been done before. And something that has never been done before, there's another word for that, and that is unprecedented. So something that's never been done before and is unprecedented cannot possibly have been passed upon by the U.S. Supreme Court. There is no way that the Supreme Court has ever upheld such an claim of power because it's never been attempted before. So this is going to be something that's going to require, to uphold this bill, to uphold this exertion of congressional power, is going to require the Supreme Court to extend its Commerce Clause doctrine beyond anything it has ever ruled before. Extend its doctrine beyond upholding Congress's power to reach wholly intrastate economic activity that might have a substantial effect on commerce, and allow Congress to reach wholly intrastate non-economic non-activity or inactivity. And that's something that it's never done before. It's something that I doubt that there are 5 votes to do, but there could be. There could be. But that gets into the 5th sense of constitutionality, and that's counting to 5. Are there really 5 votes on the Supreme Court to extend Congress's power beyond where it's ever gone before? So that's, nobody knows for sure the answer to that question, but I do know this. It's a very serious constitutional question. And it's one that is not recognized or authorized by prior Supreme Court decisions. So at the very minimum, lower courts who are bound to follow Supreme Court precedent have no authority to uphold this act. It should fall. They should actually strike this act down on the grounds that there's no precedent to support this extension of power. And then it should go to the Supreme Court, and it would be up to the Supreme Court to decide whether they wanted to extend this act, the authorization to Congress to act in this way. So let me just, I think I'm not going to talk about the mandate that's imposed on states at this point. Maybe we'll talk about this later. But let me just stop for a minute and ask what it is about a mandate that is different than a regulation or a prohibition. Because after all, the Supreme Court is free to expand Congress's power to allow a mandate like this if it wants to extend beyond its previous decisions. It's always free to do so. It's done it before in expanding Congress's power. It could do it again. But why might it not want to do that? And why does this mandate rub people the wrong way, the way it does? I think it's useful for you to stop and think about that.